property has been attached by the collector Sundargarh. So that is in spite of showing that this is the settled position of law that Madam?
Or is the regular?
Memo.
Not this page, some other page.
No, my lord, this is arising out of DRT proceeding. DRT proceeding decree was there.
But this is a regular bill. This is a special bill.
Oh, yeah.
Item 1. Item 1, my lord. Pursuant to my lord's direction, we have to produce the record, my lord.
Make use of the mic.
My lord, be audible. Pursuant to my lord's direction, my lord, we have to produce the record, my lord. I want to place some more time to produce the record.
These are all special bench matters.
Lordship.
You should be ready.
My lord,
We spend 2,100 rupees per minute. Government spends 2,100 rupees for a bench of 2 judges per minute. If you go on asking time like this, last time also time was taken.
No, last time lordship's direction was there, my lord. On lordship 12, 20.
Item 2.
May I please, my lord. My lord, non-compliance of my lord's order dated 17 July 2025, my lord. Order was to comply within 8 weeks, your lords. The order was to extend the financial benefits.
Yeah.
My lord, the Honorable Single Judge has granted the relief of financial benefits from the date of their entitlement. But the opposite parties had restricted the benefits to 3 years prior to filing of the writ petition. That, my lord, it is Annexure 1, your lordship. The operating part is that Annexure, page number 13, your lordship. Your lordship had passed the order in reference to a judgment of the esteemed Apex Court, which is at page number 12, your lordship. Paragraph 5.
On the order of this case,
My lord.
it has so many
No, it has been, my lord. Your lordships had fixed up the time. Your lordships had fixed up the time of 8 weeks, my lord. My lord, they have complied in 13 cases, not enough. They have complied in other cases, but in this case, they have.
And as time come, my lord, I will take it.
My lord, this is
Lord, page.
This is the writ appeal order, your lord.
Lordship.
Because your lordship, my lord. My lord. Order is 17/7/2025.
Yes, sir.
But lordship issue note. It's a first time come, my lord. Lordship.
My lord.
One container should. Three weeks, man. 3 weeks. Well, not sure.
Some of the action is one. Complex.
Item 3.
Item 3, Your Lordship. Order dated 24/6/2025 is not complied. 3 months time has been given by this honorable court to comply this learned single judge order. However, Your Lordship, till date, it's not been complied. Your Lordship, page number 12, last para. Again, contempt. Yes, Your Lordship. Your Lordship. However, Your Lordship, this order. Lordship.
However, in the witness of period of 3 months to comply with the order of the learned single.
Lordship.
You are enforcing the order of the learned single.
Lordship.
You have to go before the.
Obvious, Lordship.
The complaint alleges violation of EB order of the order dated 24/6/2025, whereby the state's intra-court appeal in WA number 2602 of 2024 has been dismissed, affirming the order dated 2/11/2022 entered by learned single judge in complainant's WPC number 28262 of 2022. First up, the next paragraph. The text of the operative portion of the order, except affirming the order of the learned single judge and extending the period for complying the writ in the said order, comma, nothing more is stated. First up. Therefore, the complaint can be lodged for the violation of order of the learned single judge, comma, if grounds do exist therefore, comma, there being no mandate by this bench in the order now whose violation is complained of. First stop. In the above circumstances, next para, the complaint proceedings are dropped, reserving liberty to the complainant to take appropriate proceedings in the light of what is observed above. Next.
Item 4.
Sentence. The period spent during the pendency of this complaint is liable to be discounted if other coercive proceedings for implementation of order of the learned single judge are taken.
The trips, this is an writ against the order of the tribunal, both sale and as well as the present private party has filed. May I just date? Prepared through date charts.
Your Lord senior colleague is not present, ma'am.
Your Lordship, I have to pay for an adjournment. He's out of the station.
Last time, whether a matter appeared? Or first time a matter has.
No, Your Lordship, this matter has come, and in fact, we are kind enough that today Lordship has got it on a Thursday. I can't say much because my young.
Kindly see the order dated 21 November 2025. Read the order. Your senior appears to be always on tour. We cannot help that. Kindly see what we have recorded. Again, you are seeking time. This is a special bench.
You have to be out of station on an emergency this morning only.
Where has he gone? What is the emergency? You have to tell the court, otherwise you will not grant adjournment. Where has he gone? We will verify from the concerned Supreme Court police whether what he says is true.
Yes,
You
true.
cannot run
We have
that.
no
Court
knowledge
proceedings
of-
cannot run that way.
I understand, Your Lordship.
To which place he has gone?
I have no knowledge, but he left this today morning only. So
Like this.
matter may be taken up next week.
Must understand, we are not fixing dates because it's a special bench. The entire effort of forming a bench and listing it and adjourning the matter for hearing gets is of no use actually.
And what people will think about us, because this is an online court. People think that judges are playing. They are not happy. People are not happy. I have seen people are not happy because when I went to Mahaprabhu's temple, people came and few told me that you come and pray here, but our prayers are not answered in your courts. Cases get adjourned every day. We are not here to do some tamasha. Government spends a lot of money on the judges. If you go on asking time and we go on giving time, then what your litigant should do?
The petitioner can start the.
No, that we don't do on installment basis. We are not a bank. No, this we do not like. Tell your senior. This matter, in this matter, wide order dated 21/11/2025, we had said agenda. First, next order. The above adjournment was granted on the request of senior, on the request of advocate on record, on behalf, made on behalf of the arguing counsel. First, matter is posted today before the special bench, and again adjournment is sought on the ground that the arguing counsel has left the city on some urgent work. First up. The material particulars of the urgency itself are not punished despite asking. First off, be that as it may, first off, call this matter when the bench sits next time. The request for adjournment from either side shall not be entertained. Yes.
Item 6.
Well, this, well, this matter is pending with the finance department for concurrence, my lord. Only 2 weeks time, my lord, to complex lordship kind. The instruction I have.
But we shouldn't with the instruction. He wants benefit of the order.
Yes, my lord. Yep.
Can he buy 1 kg of brinjal with this letter by showing in the market?
No, my lord.
Then what is what?
directed,
What
recommended the
benefits of the
petition.
order?
This thing.
He wants fruits of the order.
Yes, my lord.
You have not done that.
You have taken step to comply, my lord.
What he does not want steps. He wants fruits.
Let's confirm the order of the.
You are
Honorable
planting
signatures, my
mango.
lord.
Mango, now you are planting. He wants the mangoes in terms of the order.
Not
What the order says?
12.
Page 16 of the contempt application, my lord.
What?
Page 16 of the contempt application, lordship, confirm the order of the Honorable Single Judge, my lord. Then there is an outer limit to comply the Honorable Single Judge.
But on the list, learned AG, kindly come to the order dated 12/12/2025. You said that day, learned AG, Mr. G, in all fairness, submits that before the next date of hearing, compliance of the order in question would be reported by creating a supernumerary force if need be. We appreciate this act. Having told the court that you will do this, your secretary does not want to do. Does he play? What does he think of the court? Who is he?
She's the.
Who is he? Who is she? Will issue a arrest warrant against all the IAS officers. You cannot go on playing with the court this way. All litigants they are. Mr. G,
My lord.
last time you had undertaken, we have recorded your undertaking.
Your lordship, right. But they have instructed, I had told you submitted basing on the instructions of them, my lord.
First
So, my lord.
ask them whether they will report or we should issue the arrest warrant now. Why these IAS officers are not following the court orders?
They have only, my lord, the finance department concurrence is necessary. my lord.
We don't know all that.
Can I pray, my lord? Lordship may call this matter in the next week sometimes.
No, where is the guarantee?
Currently,
Yeah, you have
I'll
done
see
that. You
that.
have done that. Has
No, my lord, I'll see that.
Officers
I will
are
insist them to.
I'm sorry to say, your officers are as thick-skinned as, we will not say bovine community,
My
they are
lord.
thick-skinned.
My lord, Lordship may call this matter next week. I will see that the order is complied with.
No, what is funny? This order is not compliant.
My lord, it will be done.
No, that will not
I will
happen.
talk to the secretary for complying your lordship's order. Give me some
This
time.
court, wide order dated 12/12/2025, had recorded the undertaking of learned AGA appearing for the contemners in the following words. Reproduce that order. This day, when the special bench sits, another counsel for the state, that is learned ASC, Mr. Khandatre, seeks one more adjournment. First one. This conduct on the part of the OPs itself amounts to contempt. Apart from the substantive contempt alleged in the contempt petition. First one. Constitutional courts are there to do complete justice by ensuring compliance of their order, and not for granting adjournment after adjournment and adjournment after adjournment, as has been happening in the courts nowadays. First one. Next paragraph. In the above circumstances, the security presence by police, commissioner of police, that will happen. the Commissioner of Police, Commissioner or Superintendent of Police.
Commissioner.
To secure personal presence of the attorneys for this court. On briefly sorry.
But let it be. Let 30 years.
26 and then 30. Showing cause as to why the order is not complied with. Why is the undertaking to comply with order is not complied? Next one. Their presence will not be necessary, may not be necessary, if in the meanwhile the order is complied with and an unconditional apology for non-compliance is tendered to fair cost. The registered copy of this order by Supreme Court to hold sunset of the day. Plus, well, let it order.
Yes, ma'am.
Yes.
That's it.
Is
Will do that.
yeah.
Item 8.
Yes. In this case, your lordship on 12/12/2025 was pleased to issue notice to the contemner and the order, your lordship will kindly come to page 42, your lordship, but against the order of the learned single judge directing to the regularization of service, they have filed a writ appeal before this honorable court. After hearing, your lordship has disposed of the same, your lordship will kindly see page 42, the ordering portion. Again, within 3 months, against which they have moved before the apex court. Against which, they have moved before the apex court, and it was dismissed.
On instruction, I have appeared on 19th, my lords. I have appeared on behalf of the contemner on 19th. My bringing to my lords notice that your lordship has disposed of 43 cases by common judgment. The main judgment was challenged. At the main judgment, the writ appeal number 857 was challenged, and along with other 10, total 11 SLP was filed. My lord, I am so what I am bringing to my lord's notice. I am also bringing my lord's notice that the Honorable Supreme Court, because I was appearing along with the learned senior counsel in the Supreme Court had rejected on the peculiar facts and circumstances of the case. Thereafter, the petitioner has moved before the government to take to text on 15th, my lord. 15th January. Thereafter, we have moved the government. No, my lord. No, my lord. Because
Direction of the wind.
my lord, I agree. My lord, I agree with my lord's views, my lord. Your lordship can say it regarding sober. No, I am not saying. Only I am appraising my lord's notice, my lord. What is the? My lord, I will certainly comply, my lord, because I have duty bound to comply, my lord. So because regarding as far as this petition is concerned, his SLV is pending, but that is no way concerned. Because we are trying to taking steps regarding implementation of my lord's order as early as possible. Lordship.
Apex court did not extend the time.
My lord.
It's implementation order.
My lord.
So you complain that order, that was the very first.
My lord, 30th
That is
July
on 30th July 2025.
and regarding I am not regarding petitioners itself, that is pending. That is no, my lord.
Don't worry about it.
No, I am not the only bringing my lord is a correct fact, my lord. That's why lots of grants
No, we
of
don't
reasonable
want all
time.
this. Are you going to comply with the orders
Yes, my
or
lord.
not?
We will comply, man.
When do you comply?
Lots of grant reasonable time at least to because you have to there is a
Tell what is that reasonable time?
matter at least 2 months, man.
2 months.
Why my lord?
To indirect the.
Why I am saying so, Lord, you can see the present status of the petitioner.
Huh?
The present status of the petitioner is that, as per the change policy decision of the state, the petitioner service has been transferred to another organization, that is WATCO. Since last 5 to 6 years, he is working under WATCO. Now, ultimately, now he will observe under the WATCO, my lord. WATCO is another party to any proceeding. Therefore,
How you will do it?
My lord, that is their lookout. That is their lookout.
If you listen, then it will register in your mind, sir.
My lord.
What the court wants to fix the answer from you,
Regarding compliance, my lord.
not regarding. Why you have not complied after the SLP has been dismissed, and why you are narrating all these things? Suppose now, can we modify seeking your prayer that the order is not to be complied with?
No, I am not saying.
Of the period
And obviously,
I seek for a reasonable time, my lord,
and Mr.
because that can
already my lord has told you that Supreme Court has not extended. It is binding on us also.
Which is binding on us only. It is not extended. You have not made a prayer for extension of the period, saying that all these years, all these days you have kept the matter pending. Therefore, now extend the period for compliance. The order of the court binds the courts and binds the litigants.
Let's say, give some reasonable time and I will take.
No, your claim is unreasonable. Therefore, we don't give time.
No,
If you
no,
say
that's-
reasonable time,
Keep it, my lord. 1 month, my lord.
you file a memo. You file a memo that within 1 month you are complying with the order.
So
That we will.
Whatever you are saying, you should have filed the application.
You can't say tomorrow if you say we have not said anything.
You are
Lordship.
narrating so many things, but no application. And
My
you are
lord,
yourself
because of my lord,
said
this
that
my
you
lord.
are party, you yourself
Because, my
are
lord,
the matter.
I agree, my lord. I am
And
very, my
whenever
lord,
the
to
court is
say.
saying a word, you are saying 3 sentences without listening. In a content matter.
My lord, kindly said,
Kindly,
because
kindly,
19th,
kindly
because
have
it is
the
assigned to me
patience to listen to
19th.
the court.
19th, my lord, we have agreed, my lord, to answer 7 days before I have to take all
You
this.
put in writing.
My lord,
You put in writing that you will comply with the order within 1 month.
lordship, I will take instruction from them there because.
Then you take from telephonic instruction.
My
We
lord,
will not wait for you.
My lord.
Yeah. Pass over. This is the only method. Pass over method. Call the pass over method. You ask them if they agree, then you give it. Otherwise, the law will take its course. Item 4.
You are unable to convince him that instead of uprising regarding the position, he has to comply.
No,
You
but-
will never do it.
No, my lord, I am not there. Only the order.
Mr. Mahanti, the problem is that you go on arguing, we don't have a choice other than punishing him after
No,
directed by the Supreme Court.
Lordship, tell.
That's the problem.
Sorry, madam.
If we, no, we are extremely sorry that you are telling us sorry instead of coming to the point. We are extremely sorry. You are yet to say that line that you are telling so many things, but irrespective, only one word is missing, that we will comply.
Because you
You
have
can
not
check it
the
out.
legal battle at the Supreme Court.
You can check it in the is it live. You have never said that we will comply.
No, my lord.
Because that's the advantage of
I
transparency.
already positively said them. You at any cost you comply the immediately as early as possible because it is honorable court. You will take a stringent action against you. And he's because of it's out of station. I cannot because without his.
Sir, somebody out of
because
station, if you
ultimately
record Mr. Mahanti, then that will tell upon his post. Because he can't leave the administration in the vacuum.
No, right, my lord.
Exactly.
There is
How
no
can you be
precise-
wrong also?
Yes, my lord.
Suppose you record that he's unable to provide instruction because he's out of station.
My lord.
Are you sure that will inure to his benefit?
My lord, the benefit.
Because he's not the ultimate authority to leave everyone. He has to assign somebody. X, Y, Z, who is a...
After Supreme Court, what more reliance?
Only
The-
adjournment to 1 week.
1 week.
Because otherwise, unless I appraise my lords, the
appraise?
My lord. By which day they will comply, my lord? By which day they will positively comply to my lord's order? I will tell them, my lord.
You will tell. But they will not abide by your advice. Our orders only are not complied with. The instructions they
Because
will not
for the
care
first
to.
time, I have this is my first appearance before the contemplative district.
First appearance is for reporting compliance. This is not accused appearing on magistrate courts. This is for reporting compliance.
My lord. Because
The writ appeal. Write one number. Correct the number. Writ appeal
Merit appeal number 845 of 24.
854 of
And this is my-
24, along with the companion appeals came to be negatived by
My lord,
this bench.
this is number, my lord.
Why the
His case.
order dated the order 37/2025 affirming a learned single judge's order, common order dated 22/3/2024. First one. While disposing of the said appeal, this court had granted, had framed the compliance portion of the order as under. See, in the above circumstances, then the appliance officers are directed to implement impugned or so and so. That entire 42. Okay. Next paragraph. 28. This order was put in challenge by the contemners in SLP number
Giving that.
354.
SLP number so and so.
3548822.
Write down this one. And the same came to be negatived by the apex court of the country by the order dated 15/1/2026. First one. Apparently, no extension of period for compliance as fixed by this court had been sought for at the hands of apex court. Is obvious. Not obvious, not apparently. First one. Learned panel counsel appearing for the contemners. Contemners submits that if a reasonable time is granted in the circumstances, his client should report compliance in terms of the said order. First of all. When asked what is reasonable time, he says 1 month. First term, that is too long. And a successful party in a legal battle cannot be asked to wait and wait. First term. Next paragraph. In these circumstances, a period of 3 weeks is granted for reporting compliance of the order in question. First of all, for reporting compliance of the order and to report compliance. First of all, in the event the compliance is not reported comma, whatever be the circumstances, comma, the contemners run the risk of arrest and detention. Arrest and detention. First. Next, call this matter when 3 weeks will be over. 12th February.
So,
On 30th, we'll have them. On Friday is a good thing. So that we started sending sheets. All this nonsense.
Deep knowledge.
Kindly permitted to withdraw.
You want to withdraw?
My lord.
Why not happy with the court?
No.
You have sent a memo.
They have filed the IA for modification.
Modification. That IA she wants to withdraw. Or petition itself you want to withdraw. What is that? Petitioners or does not want to press in the petition. This, I have to reproduce it right properly. Otherwise, Ren and Martin may commit suicide. Give that. Kindly advise. Help. Yeah. Serial number? 41. What even there are 3 WPs. All the 3 you want to withdraw?
My lord, my lord.
Are you sure?
My lord.
Learned counsel appearing for the petitioner seeks leave of the court to withdraw these petitions by filing a memo which reads as under. First, in the above circumstances, petitions are disposed of as having been withdrawn. First, registry to send a copy of this order by speed post to the OPs immediately. Yes.
item 1.
Item 1.
Yes, sir.
We have filed a compliance affidavit.
You have complied with the order.
Yes.
Have they complied?
Your lordship
But I am appearing on behalf of the opposite party number 4.
Yes.
I have filed an IA for recall of the last order for the reason that I am not a proper party to the present content petition. There was no order passed for me to comply. So one is for in respect of the opposite party number 4, I am filing.
You are required to file compliance report.
Opposite party number 1 to 3.
1 to 3.
One state government.
One has filed.
One. Compliance is done now.
Compliance is done. Your lordship directed.
Okay.
It is ensuring the opposite parties to solicit any information that petitioner has requested.
Anyway, he only says contemner, counsel for the complainant says it's complied with.
It is complied with.
And you also say that.
Yes.
The complaint alleges violation, non-compliance of order dated 4/8/2025 entered by this court in WPC number 17781 of 2025. First up. After service of notice, learned EGA appearing for OPs submits that there is a compliance of the order. Is there have you tendered apology?
Yes.
Read that apology. It admits that the said order has been complied with. First up.
My lord, the opposite party contemner has every respect and regards to the order passed by this honorable court, and the same has never been violated by the authority, and for inordinate delay in disposal of the representation makes unconditional apology, which is never intentional nor
The OP number, contemner number 1.
one.
Contempt number 1 in his affidavit dated
Affidavit dated, sorry, it is 21st January 2026.
21/1/2026 has also offered unconditional apology for the delay proved in reporting compliance. First off, Learned Counsel appearing for the complainant on being asked, submits that contempt proceedings be dropped. First one. Next paragraph. Apology is accepted. First one. In the above circumstances, the contempt proceedings are dropped.
That's great respect, my lord.
Courts having been made easy. Before that, one more. Learned Counsel, you appeal for whom?
Lords, I appeal for the opposite party number 4.
One more paragraph. Learned Counsel appearing for contemner number 4 submits that there is no direction as against his client. First one. The same is accepted. Accepted. Okay. Done that. Yes, this one.
Item 2. Next, my lord, item 2. Item 2, your lordship may kindly have a look for the order passed in the writ application dated 8/8/2025.
Lord, sir, I am the petitioner. Lordship, kindly see the order dated 16/10/25.
I'm coming to that matter.
No, you are the contempt has to apply independent law, not through the council. I am just bringing to lordship's notice order dated 16/10/25.
If it is complied with.
No, they have not. They have not served a copy with me. No, they have not.
They will not have a copy to you.
Yes,
it is for the court. Contempt is a matter between the contemner and the court. You are only postman. You have got it to our notice. You have to leave it there.
No,
Till then, give copy. You serve copy also.
I'm giving.
What was the order?
Order was, I was blessing that. Lordship may kindly have a look to the order. In the above circumstances, the operative portion I am placing, this writ petition succeeds in part and succeeds in part.
Accommodate petitioner in one of the vacancies in the post of assistant teacher.
My lord, lordship may kindly have a look to.
In the 5th OP school forthwith.
My lord.
And report compliance within an outer limit of 6 weeks.
My lord, for the delay I beg an apology. Lordship may kindly have a.
Have you given the post to him now?
Lordship, annexure C/3, your lordship may kindly have. Page 9. Page 9. Page 9. Pursuant to instruction issued by the government of Odisha in the Department of School and Mass Education by letter dated 21/1/2026 communicated by the Director Secondary Education Odisha Bhubaneswar by their letter dated 21/1/2026 and order dated 8/8/2025 of the Honorable High Court of Orissa in WPC number so and so. Purnima Swai, BA, B.Ed Assistant Teacher is hereby adjusted against the existing retirement vacancy TGT Arts post with effect from 21/1/2026. She will get the block grant at the rate of 40% as per GIA 2013 and in pre-revised scale of pay 9,300 to 34 GP 4,200 or SP 2008 subject to outcome of the writ appeal number 1.
Yes, there is compliance. Okay. Right. The complaint alleges violation of the order dated 8/8/2025, wherein the operative portion reads as follows. Next paragraph. After service of notice, the contemners have filed an affidavit. Is it affidavit?
Yes.
Compliance affidavit.
Compliance affidavit.
Sold to by contemner number 3 the district education officer
Khordha.
First off, reporting compliance and offering unconditional apology for the delay brought in reporting compliance. First off, next paragraph. The document at Annexure C3, which accompanies the compliance affidavit, reads as under. All this has happened yesterday.
Yes.
That's good, actually. 1, 2, 3, 4, 5. 5 officers have acted immediately. Very good.
Thanks to your lordship.
Learned
Officers have.
counsel appearing for the complainant agrees that there is compliance. First, next paragraph. In the above circumstances, the contempt proceedings are dropped. Yes, next. Item 3.
May people visit.
Yes.
Non-compliance of the order. Highway
What was the order?
Highway 2025. Operative part of the order, my lord. Page 8, running page 8 of the content person, my lord. Para 2. In the above circumstances, read person disposal time of compliance of the undertaking to give the court.
Order is dated
5/8, 2025.
5/8/25. It is an undertaking given,
My lord.
actually. In terms of undertaking, matter is disposed of. Given to the court is 8 weeks. For time for compliance of the undertaking, given to this court is 8 weeks. Reckoned from this day. In that connections, all contentions are kept upon. What have you done, sir?
My lord, an order was passed.
You have passed the order.
Yes.
When it, what the order is against or in their favor? Just I want to look into, just to say we have complied to escape contempt. How we have done, we'll see that. What has been done?
A speaking order was passed in response to your lordship's order, my lord. Solicit.
What has been done?
Now in exercise of power vested.
This is done on 19.
Yes,
That's also good.
19. A prayer for approval as DGT headmistress in charge
Is rejected.
rejected, my lord.
We challenge this. They have complied. This is a long order.
Right.
Though in urgency they have done. Anyway, complaint alleges violation of order dated 5/8/2025. First off, after service of notice, learned AGM G appearing for answering contemners submits that the order is complied, although with some delay. First off, he also draws attention of the court to the any apology is tendered, Mr. G.
My lord, we have not filed any affidavit.
All right. Do you tender apology orally?
Orally, I'm tendering it.
Learned AGM
For the delay.
Mr. G appearing for the contemners on their behalf and the instruction tenders unconditional apology for the delay through. First off, the compliance is accepted and apology also. First off. Next paragraph. The operative portion of the order dated 19/1/2026, whereby the compliance in terms of compliance reads as under. Just pull out this one. Next paragraph. Here. Put one back then. Reproduce them. In the above circumstances, contempt proceedings are dropped, reserving liberty to the complainant to mount challenge to the order, compliance order, if he is so advised. Yes.
Item 4.
Next.
Item 4.
Item 4, my lord. One affidavit of compliance we have filed, my lord.
Compliance you have done. What was the order?
Order was
Page 12 of the content petition.
Don't change the paragraph when I'm reading the order. Grant of increment.
My lord.
My lord.
Have you granted the increments now?
My lord, here there is a problem. He is claiming relief basing on a document which is meant for the government employees. He is
But what
working.
the court said, what we have said in the
It
order,
is only disposal.
look into the grievance.
Yes,
There you have rejected that now.
yes.
Which is that order 20
It is 20.
January 26.
Yes.
Wow, all of a sudden government machinery has become so active.
We have done that.
The complaint alleges
He is an
order
employee of a
dated
non-government
violation
aided
of
institution.
order dated 37/2025. First off, after notice, the contemners having entered appearance have filed copy of an order dated 20 January 2026, whereby the grievance of the complainant has been addressed in terms of the order in question. First off. Any apology is being tendered?
Yes,
No apology.
I'm back. Yes, my lord.
Yeah,
Definitely.
same sentence. Definitely tenders unconditional upon instructions and tenders unconditional apology for the delay proved. First, in the above circumstances, contempt proceedings are brought, preserving liberty. First, same format you have to keep that, huh?
The two matters are there and connected.
Both the matters.
Two matters.
Both the matters.
Both the matters.
Yes. Item 5.
Item 5.
All contained all the three matters. Yes, sir.
Affidavit was filed by the bank, and so far as controller of accounts, I am giving this instruction they have given to me, my lord.
What is the order?
19.5, no deduction from the commuted bills.
They had deducted.
They have deducted.
They was deducting, my lord.
No. There is no deduction. Deduction was stopped, man. Stop now. Stop.
Now stop.
And the amount deducted amount have been credited.
Remitted back.
Remitted back.
Remitted back. Complaint alleges violation of the interim order dated 19/9/2025, passed in pending WPC number 25607 of 2025 and WPC number 25642 of 2025. First, learned after service of notice, the contemners appearing through the learned AGA, submit that the violation of the interim order has been made good by retracing the steps, semicolon. The whatever amount has been deducted after the order in question, has been remitted back to the complainants. First up. Thus, they also offer. You offer apology? Yes, you have to say that. In so many people will be looking back there. Mr. G, appearing for the contemners, accepts. Offers apology, unconditional apology on authorization. First time. Learned counsel appearing for the complainant. Are you happy?
Yes, yes.
Complainant.
I am for
submits
OP6.
that contempt proceedings be dropped in the circumstances. First, next paragraph.
I am for OP6.
Ordered accordingly and contempt proceedings have been done. Okay.
My appearance for OP6 that.
Next. Item 6.
Item 6, your lordship directed to prescribe for considering the subject of representation and also to inform the result of such consideration.
To them.
They have considered it and rejected the.
Because of threat of the contempt, you have rejected. Because they brought the case. How you have rejected? Show that to me. I will look into.
Filed, my lord.
In
order
urgency,
was
if you
first.
reject, that will be another contempt. Just I want to look into that. Where is that order?
My lord,
Filed.
kindly have a glance at the so cause false affirmance have been made.
Where is that order? You will find it.
So cause affidavit कहीं
दोषी नहीं हो तुम
नहीं
सब
बहुत नहीं चलते आया So lordship,
सर्विस यही किसो ये फाइल करो
You filed the receipt.
false affirmance have been made.
Let me look into it. You have to share copy of that
Yes,
order with the
definitely.
other side. No?
My lord, it is there.
When it is passed, suppose if you have done it in urgency,
Unless-
then
my
doubt
lord-
arises.
My lord, unless it is filed.
Eh? Affidavit is there.
Yes, it is filed, my lord. It cannot be filed without serving a copy.
Chandra Patra. District Education Officer and the responsibility of 2 months is prescribed for considering the subject representation. Representation was for what?
Representation.
For rehabilitation appointment, my lord, petitioner has been, the approval has been made
Again.
since 2014 for getting appointment.
Consideration. There is a stay of the.
No, my lord, this is false affirmation.
Kindly sit down. Sit down, sit down. We'll call you. We'll not pass any orders till you are heard in the matter, though that hearing may not be that elaborate. Yeah. Go to the order. No, the compliance order. Where is that order, Mr. G? Give a copy of the order. Just I want to face it.
My lord, it is quoted there, my lord. Paragraph 2,
They actually it said only consideration.
consideration, my lord.
Give a paragraph 2. Just I want to look into whether the things are done with bona fide or not. If it is done only to ensure dropping of the contempt proceedings, then I will not drop.
My lord. Quoted. My lord, can I pray, my lord? Lordship may call this matter some other day.
But some doubt arises.
Yes.
Actually.
My lord, but I submit, my lord.
Because this is done yesterday.
No. It was
20 January.
day before yesterday
Day before yesterday.
or somewhat.
Oh.
My lord, but I submit, my lord. Lordship may call this matter some other day so that
You keep this with you.
Yes.
And that day, suppose if they want to, we have not yet served all that, you give back that one. In the event they want to do the things properly, let them.
I will
Otherwise, I will not
Yes.
leave that office.
I will ask the government to.
Yes, appears to be a wrong order. But you cannot go on harassing the
No,
people.
no, not
Yes.
like-
You give back everything.
Yes.
So that-
You give me back.
Yes. Reluctantly adjourn to adjourn, call this matter. Payday which is the date? 30th. 30th? We'll call it. Okay. You warn your officer.
Yes,
He
definitely.
has not done properly. He is doing only only for IWAS purpose. That impression I gathered. Anyway, you can argue the
Let me see
matter.
my.
Yes, tell them. Not, it is not like that. Not for escaping from the contempt court.
No, my lord.
No.
Definitely. I will not allow them to.
Yes.
Item 7.
My lord's item 7.
Yes.
The order for personal appearance of police officer. Your lordship was directed to serve the police notice on the contemners.
Yes.
It was
did not
served.
serve.
It was served, my
When
lords.
it was served.
My lords,
Just to give me the date.
2020
When the order was made.
order was made 1512,
1512.
my lords.
When that was communicated to the police.
Police on 28/12/2026.
28/12/25.
25.
When
It was served on 6/1/2026.
26. When report of complaints is
My lord, service return, he has failed to comply. That is present.
From this side.
He should have informed the court that he has liked, he has not done.
Why have you not,
He was
reported
not
complaint?
aware, he'll.
That protection applies for that.
Learned AGA Mr. Zehura appearing for the contemner submits that pursuant to order dated 15/12/2025, which was served on the jurisdictional police on 28/12/2025, the court process was served on the contemners on 6/1/2026. Person. On being asked why compliance was not, the service report was not filed with the registry, he submits that there is a small lapse and hereafter the same shall not be repeated. First up, the police officer, Mr. So-and-so, also sincerely says that in the rush of things it has happened and that hereafter that lapse would not happen. First up, this is appreciable. Next paragraph. If you relieve him now, come to the other point. Who are the contemners?
Contemner university is
University. Your VC and registrar, they do not want to comply with it.
6/11/2000, the police officer said, 6/1/2026, we received this.
Yes.
Thereafter, 2 days holidays, and on 12th, the chief minister visit program was there. On 13th and on 16th, they sent it to me at evening. I filed it on 19th. Means
that is not the point. Order was made when?
Compliance matters. That compliance matters will prefer appeal. The university prefer appeal.
Appeal, is there any stay?
Well, no stay matters. So that
Then
we have to know.
We'll direct the police officer. Call that police officer. We'll direct them to arrest.
Well, kindly visualize once the matters with already. Matters should
Where is the stay?
Matters should be beat equitable matters. We'll move it. We are trying to move it.
No, we do not know all that. We want compliance of it's our duty. You have seen Honorable Justice Padula's judgment now. The court which passes the order should ensure its compliance.
But I am not disputing on that. I only pray some time so that I will move the memo, my lords.
No, that time will not give because already time is given for doing the things. But unless you move original application seeking extension, this contention will not retain it.
So far, my lords,
17/9 it happened.
Yes, my lords.
17/9 is the order.
My lords.
Correct? Yes. It had given you how many days time for compliance?
4 weeks probably.
4 weeks.
8 weeks.
8 weeks.
8 weeks. That will be around 15/11 it will be. 15/11 it will be. When did you file appeal?
Appeal, my lords, we filed on 16th, my lords.
16/11?
Sorry, my lords, the duly signed Baklatnama received. We filed it on, my lords.
When writ appeal was filed?
Writ appeal was filed at the 20th.
20th of
January.
20th of January.
My lords.
Just day before yesterday. After service of notice.
After on the very day it has come with signature, but in fact, by the time I received, the counter was closed.
So when the limitation period expired for the order?
Limitation period might expired?
Yes. No. You have to take action against your vice chancellor and registrar of the parties.
Both are parties.
Yes.
We beat equitable. I humbly pray my lords folded hand. give some time so that I will move before the honorable court, my lord.
No, that is not the duty of the contempt court. Contempt court is to punish the contemnor.
But that, I don't dispute in respect of all this, but so only humble prayer that they have already moved it in the appellate court. That is matter relating to regularization.
You have moved after the threat by this court. It is 20 January.
No, before that, it was under process.
Court can take judicial notice of everything.
Before that, my lord, so that was under process.
No.
They signed it and sent it on system.
Huh?
They signed it and sent it because the affidavit and all these things they have to do, and they've done it and they sent it to 16.
But time barred it is.
Well,
it is time, but you comply and subject the outcome of the order, appeal order.
That part is there. But may submit one thing. Here in this case, it is regularization. In case regularization, the pilots already clarified that they will get all these benefit on from the date of the filing of the judgment. Suppose we will succeed in the report, it's different.
If you succeed very well, you can take everything back.
It is a different thing, but fact remains, if it is dismissed, they have to get all this benefit on from that date. May I pray, my humble request?
Order was made on 17/9/2025 for regularizing the services of the complainant. First off, a period of 8 weeks was accorded for reporting compliance of the said orders. First off, learned counsel appearing for the contemner submits that writ appeal has been preferred against the said order on 20 January 2020.
Signed on 8/1/2026, sorry, 18/1 and filed it on 21.
That's fine. 20 January 2026. First, counsel for the complainant submits, contemner submits that he has got an arguable case in the writ appeal, and therefore some time be granted so that some interim protection would be sought for at the hands of the appellate court. First up, this is opposed by the learned counsel appearing for the contemners. First up. Next paragraph. It is a settled proposition of law that where the court fixes the period for complying with its orders, the parties concerned may seek extension of the time at the hands of that court by moving an application under section 148 of CPC 1908, which are made mutatis mutandis applicable to rules of this High Court governing that writ petitions. First off, such an application is not moved. First off, such application cannot be moved in the contempt proceedings. First off, next paragraph. In the above circumstances, the police is directed to.
I'm here, my lords.
You are what for? What we should do with you?
I'm here, my lords. I pray, my lords.
The compliance.
My lords, I pray, my lords. Either I will get the stay or I will comply. My lords, my lords, client will have some time.
Call this. In the above circumstances, a short accommodation is granted for reporting compliance. First of all, call this matter on 13th February. Is it Friday? It should be Friday. At least 1-2 days, they should not be able to do anything in the court. Yeah, 13th February.
So I will get it. So this respect, I will try my level best to get it.
Very reluctantly adjourned. So and so. Perfect.
Item 8, Your Lordships, first my deepest apology for having taken so much of time to comply the order. Your Lordships, the order which was supposed to be compliant was an interim order dated 10/10/2025. What had happened is, Your Lordships, there was some
complaint.
Yes, Your Lordships, complaint.
No complaint.
Yes, Your Lordships. What the first part compliance affidavits on record.
What was the order?
Your Lordships, we had actually withdrawn a benefit giving to
that you have restored to him now.
Yes, Your Lordships. What was supposed to be done?
Say, yesterday I have received the complaint affidavit.
Only in these 2 days, law of contempt has changed in this state. In your state, law of contempt is changed only in 2 days. Anyway, now they have restored it.
Everything restored.
And apology is being tendered. Why they did do? What is the qualification of those people who did all this?
No,
Just
yeah.
tell me.
So the VC and the registrar were deepest apology.
No.
Deepest apology, Your Lordships.
Pay
We are-
10,000 rupees.
Your Lordship,
They are VCs and registrars. They are not some Tom, Dick and Harry.
Lordships.
And they have also in that university law course is there?
No, Lordship.
No law course.
No.
Therefore, they need not obey the law.
No, not at all. Your Lordships,
10,000.
I will beg apology. And
don't
it will
say-
never happen again.
Madam.
Your Lordships, it will never happen again. Your Lordships would take my word. It will never ever happen.
Complaint alleges violation of interim order dated
Your Lordships, 10/10/2025.
10/10/2025 entered in pending WPC
28693 of 2025.
25. First up, after service of notice, the contemners have entered appearance to the Learned Counsel on record. First up, Learned Senior Advocate Madam so and so submits that her clients have offered unconditional apology for the lapse that has happened, and that they have also complied with the order by restoring the benefits to the complainant on 20 January
2010, everything to his
20.
bank account.
First up. Madam also submits that apology be, the counsel also submits the apology be accepted and contempt proceedings be dropped. First up, with this proposal, Learned Counsel appearing for the complainant. You agree with that? We'll drop the proceedings. Now we have got everything.
Madam, I will only madam, I will take instruction, madam.
In the above circumstances, the contempt proceedings are dropped. Yes. Item 9.
My lords, item 9. I have filed compliance affidavit. My lords, the direction was in the above circumstances, this petition is allowed, and there was a direction to regularize the service of the petitioner with effect.
5/1/2014.
My lords, it has been done. It has been done.
Regularize.
My lords.
If you regularize with retrospective effect, whether the consequences.
Consequential, I have stated in my application. I seek a little time for that, complying that also, my lords. My lords,
This is dated 21/1 January. When are you going to give the benefits?
Benefits, my lords, is present also, the director.
Ask them. Why they did not comply the order all these days?
Tendered apology.
That is all right. But apology, whether to accept or not, is the discretion of the court. Ask them to pay 25,000.
My lords, they have fixed the amount also yesterday.
Again, I do not want the litigant to go and beg in front of their table.
My lords, kindly grant 4 weeks time.
For 4 weeks. Why? When it was supposed to be complied with? Order was to be complied when?
My lord, 4/9 was the order. 3 months was granted, my lord.
Order dated?
4/9.
4/9.
3 months.
3 months was given.
12 was the last date, madam.
Now they are complying. They are assuring that within 2 weeks they will be making the payment. If they do not make payment, I will say that you will get another extra 50,000 rupees. All right? And a contempt also you can revive. It will come before me. The order, why ask them why they did not comply with the order. Apology will look into. Why they did not come. Suppose if the thief returns the goods, offense of theft does not come to an end.
My lords, here what they are doing, they are seeking permission of higher authorities.
What for?
That if anything goes
wrong. If the higher officer does not give the permission, then you will violate the order.
No, my lords.
What is fun in doing that? I have strong presumption.
My lords, my lords, the message is clear now. It will be
from these people.
My lords, the message is clear now. Now they will act.
No, the message should be still more clear.
My lord, enough.
Complaint alleges non-compliance of the order dated 4/9/2025 entered in complainant's WPC number 18172 of 2024. First off, the operative portion of the order reads as next. After service of notice, the contemners having entered appearance to the learned AGA offer unconditional apology for the delay in complying with the order in question. First, the compliance order is dated 21/1/2021, which reads as under. Next paragraph. Learned counsel appearing for the contemner, learned AGA Mr. Devara appearing for the contemner, who are also present before the court. All they are present before the court.
My lords, both.
2 persons.
2 persons. Director and
subject that the amount, what is the amount payable?
My lords, it will be computed. My lords, 6. There is a committee to sit and pass orders. That is why 4 weeks time will be computable.
Financial benefits payable in terms of the writ order shall be remitted to the bank account of, you give your bank account?
Yes, madam.
Bank account.
That is open number 2. And you open number 2.
Bank account of the contemner, whose particulars are readily available with the OP number, the contemner number 2. If 2 weeks time is granted. First, with this proposal, learned counsel appearing for the complaint is agreed. First, next one, in the above circumstances, these proceedings are dropped subject to revival, subject to the amount being paid to the complainant in terms of the order as a consequence of retrospective regularization within an outer limit of 2 weeks, failing which the contemner each of the contemners shall pay rupees 50,000 to the complainant from their pocket.
My lords, only pay 4 weeks.
4 weeks. 4 weeks. But if they do not do, you tell them 50,000 each you have to pay. First off, this will be in addition to the possible arrest and detention. Yes. Item 10.
My lords, item 10, complaints affidavit is filed.
Anybody to challenge that order?
Complaint alleges violation of non-compliance of the order dated 8/9/2025 entered in complainant's WPC number 24333 of 2025. First off. Next paragraph. After service of, you are also filing compliance report?
My lord.
Any apology is tendered?
Yes, my lord.
Learned after service of notice, contemners appearing through the learned AGA submit that there is already compliance, although with some delay, and therefore they have offered unconditional apology. First, learned counsel for the complainant very fairly submits that there is compliance of the writ and therefore content proceedings be dropped. First, I agree. First, in the above circumstances, proceedings are dropped.
Liberty to challenge that order. They have rejected.
Liberty to mount challenge to the compliance order, if so advised. First, in that contention, all contentions are kept open. Liberty to the complainant. Yes.
Second case also same, but complied on 20th January.
Same. That order dated, same order.
No, the order different order.
Order dated 21/2026. No, that read petition order.
22, 8, 25.
22 August 2025.
22/8/2025 entered in WPC.
23/2/14 of 25. 23/2/14.
23/2/14 of 20. Okay, rest of the
Liberty month.
Same. Next, item 12.
Alerts item 12.
Yeah.
It is non-compliance of order dated 6th August 2025.
6/8/25.
25.
Where is that order, brother?
The order is at page number 11 and 12. 8 weeks time granted.
What was the order?
Only the mother's name is wrong. Very small grievance. Only mother's no disposal not. It is Peta Medkami. Mother's name is in the 11 page number 11. Your Honor's order wrongly Annex 3, where his name of mother is wrongly shown as Peta Medkami instead of Bhime Madkami. Small grievance.
Have not been done, Mr. Panda?
It is of union. It is of union.
First time it is.
First time.
Yes, it is union.
Issue emergent police notice to the containers.
5041.
Returnable on 13 February. Yes.
Notice by speed post.
Police. Yes. Yes. Item 13.
Obliged.
My lord, this item 12. Sorry. It is not state, my lord.
Therefore, union.
Yes.
Yes. Next. Item 13.
Item 13 of the petitioner lordship. So for violating the order dated 5/8/25 in WPC 21117/25. Lordship, Annexure 1, page 10. 8 weeks time was given.
For disposing of the representation.
Yes.
What happened?
No instruction is the first time it has come, my lord. I will seek instruction.
Issue police notice to the containers. Yes. Item 14. Returnable on 13/2. All matters also put 13/2. Hon'Ble that day.
Item 14, man.
Yes, sir.
Non-compliance of the order dated 22/8/2025. Time limit was granted to your lordship 8 weeks.
Same order. Next. Item 15.
But there is a sub-item that I have filed a petition for modification that is to be listed separately.
Which one?
Along with that content petition, there is a
item 14. 14.
Item 14.
Separately, it has to become. What modification you have sought for? Tell.
Because the order has been obtained by exercising fraud on court, stating more incorrect facts. Almost all the facts stated in the petition are incorrect. So that's why I filed intervention.
You were not party to that?
No, I was not a party to that.
Then you have to file under 63 Supreme Court. You have to file separate petition seeking review of this petition 63.
Yes.
Shivdev Singh versus so and so.
So I have filed a petition for implement of party and modification. That is permission.
No.
I have checked up.
Not permissible. Not permissible.
So Lordship may call it some other day. I have checked up.
We have already passed the order yesterday, day before yesterday. So many orders have happened. 63 Supreme Court says 5-judge bench. The same judge has treated the matter. We have to file a separate writ petition, not review petition, seeking review of the order passed in the earlier writ petition.
Let me check up one. Only one day. I have searched and I had found a judgment. I have not brought.
Where is that judgment?
I have not brought it. One day, Monday or Tuesday.
Post
it is permissible. That is why I filed
WP separately on 13/1/2021. Look into that judgment. We have already passed a similar order.
I will verify that. 63 Supreme Court and
Shivdev Singh
versus State of Punjab.
61
correct.
Versus State of Punjab.
Yes. Item 15.
Item 15 may appear, my lord. This is a matter relating to rehabilitation appointment, my lord.
This Honorable Court has directed on 19th of August 2025 by causing the rejection order, directed the opposite party number 4 contemner to reconsider the application of the petitioner afresh in terms of the judgment 15.
That
Jitalua, which has been annexed and annexed.
They have not done anything.
They have not done anything.
Issue police notice, emergent police notice to the contemnants, returnable law. Yes. Item 16.
Case contents. Consider representation 18/8/2023 order has not.
They have not done.
No.
All right. Same order.
Item 17. Order dated 10/10/2025. The Lordship directed for disposal of reproduction.
Same order.
Item 18.
Hello, item 18, I have got the petitioner the violation of order in rate petition number 21536 of 2025. My lord, the violation is under annexure 1, page number 9.
Yes.
Item 19.
Item 19, Your Lordship.
Yeah.
We granted 4 weeks' time, Your Lordship. The government has decided to appeal, Your Lordship. We be granted 4 weeks' time. Either we obtain a stay order, Your Lordship, or we comply. 4 weeks' time.
Issue police notice for on 13 February. Police notice. Yes.
Item 20.
Rehabilitation assistance scheme. Madam.
Police notice, emergent police notice, returnable law. Next.
Item 21.
21, Your Lordship. We received instructions, Your Lordship.
You complied with the order.
Your Lordship, we cannot because of the government's implement of the government has withdrawn that rehabilitation assistance scheme after 2020, Your Lordship. But it is under active consideration now with the government. If the day the government allows, Your Lordship, we will.
Issue police notice.
Item 22.
22, we have complied, Your Lordship. We've received a draft compliance affidavit. 2 weeks' time may be given. We file a compliance affidavit.
Issue police notice.
We have complied, Your Lordship.
Where is the complaint?
We have,
Sure.
it is a draft counter, Your Lordship.
No, I look into the order, compliance order. Give that compliance order.
Sure.
Yeah, take that.
They have treated it as to be regularized that leave period, and they've said no work, no pay, Your Lordship.
What the court had said.
The court had said to look into the representation and.
That's all. Yes. Who appears for the complaint? Then complaints.
Let them file in copy to me.
Not to you. You are not contempt court. You are only complainant. But complaint alleges violation of order dated 6/8/2025 entered in WPC complainants WPC number 21074 of 2025. First time. At the admission stage, learned ADA Srimati so appearing for the complainants has filed. Give a copy of this.
Yes, Your Lordship.
Has filed a copy of the compliance order. Wide office order number 127 dated 9/1/2026. Penultimate paragraph reads as under. Which reads as under. Entire order you prepared. That copy you have to give now.
Yes, Your Lordship.
Now you get the rest of this one. Okay? Yes. In the above circumstances, there is compliance of the writ. Substantial compliance of the writ. And therefore, these proceedings are liable to be dropped with liberty to the complainant to lay a challenge to the objectionable part of the said compliance order. If grounds do exist, therefore, if that person is
Item 23. Order 6825, your lordship directed to release the terminal benefit.
Not given.
Within 80 weeks, no.
Terminal benefits are not given.
No.
University.
Yeah.
Issue emergent police notice to the contemners. Yes. 13 February. That day you have to tell to give me sitting that day, single. Okay.
Item 24.
May appeal. On compliance with order date 28/2025, it is only page 16 lordship. Lordship directed the opposite part to consider the dependence of the petitioner and the same may dispose within 8 weeks.
Issue emergent police notice. Is it a DB judgment or single judgment?
Single judgment.
Police notice, returnable law. Next.
Item 25.
The order dated 19/8/2025 has not been complied with. 6 weeks time was given for compliance of the order, my lord.
Who should comply? Who is the contemner?
Opposite party number 4, my lord, BO.
Issue emergent police notice, returnable law. Yes.
Published.
Item 26. Your lordship directed for disposal of repentances. Order dated 9.
Next.
Item 27.
Order dated 26 November not be complied. Trace content.
Same order.
Item 28.
May I please elaborate? Non-compliance of interim order passed by your lordship by the Register Dharendra University Lordship. Order dated 21/11/2025. Annex 1.
Issue police notice.
Same
order.
Item 29.
To all the orders you have to enter one thing. The container, one that is box. Arresting detention. Compliance is not reported on the next date of the yes.
From 29, I am the petitioner, my lord. But I seek my lord's kind permission to pass on this IA, my lord. Filing
IA. You have to file in the register.
I will only explain, my lord. I will follow the formalities. This IA objective is, my lord, to grant me some time for full compliance of a particular direction. My lord, full compliance with regard to, my lord, order direction number 2.
You want time for compliance?
Till 29th of this month.
Yes, I have filed a
he is separate, my lord.
For the opposite party, 4, 5 and 6, you lordship directed to deposit 10 lakhs. They have deposited. I have filed an application for release of that account in mine.
What is the amount to be deposited?
Before the BDA, already you have deposited.
My lord had directed me to deposit 10 lakhs for his benefit, which I did in time, my lord. On 8th of January, I have already deposited, for which he filed an application for withdrawal. Without, I am supposed to deposit, my lord, 1,25 lakhs with BDA. I approached them on 19th. I gave a letter to which they have responded.
Just reverse. We sent a letter on 17/1/2026 in response that whether you complied or not, to appear before the secretary and say, in letter dated 19/1/2026, my learned friend's client requested that we may be issued NOC, Babel loan and all these things. He has requested.
How ulta, I don't understand. I approached them on 19th. Asking them to please give me your account number to remit the account.
You give account number now.
I will give that.
And they have fixed the date to 29. I have served the copy.
I fixed the date 29 to show that whether you have complied the order of the honorable court or not to give these receipts and all these things. 17/1/2026.
Which was the last date for making deposit?
But sir, my lords have granted.
That is a little bit confusing. I read, my lord. May I be permitted, my lord?
Yes.
A writ of Bandavas issues directing OP number 2 to 3 BDA to allot the plot K so-and-so, measuring so-and-so, pursuant to the auction dated so-and-so within 4 weeks, on petitioner remitting a sum of 1 crore 25 lakhs in 5 equalized fortnightly installments. This is slightly, but my lord gave me liberty, my lord, to all the parties, gave the liberty to all the parties. If any difficulty arises in giving effect to the
You
intent,
can come before court and ask for that. No, we are asking you, when are you going to deposit? Leave all the steps.
within 29th,
By 29th, by 29th.
With-
Okay, my lord, that will do. Let us not fight.
let me explain.
We are agreeable, still you want to explain?
No, within 29th, if he fails, my lord, everything goes.
That is
Full compliance, my lord, from both the sides.
no, there's no.
Petitioner shall deposit, BDS shall do the rest.
Well,
Formal.
let that one.
Learned counsel fee, thanks for appearing for the petitioner in what the WPs?
One WPC, my lord.
In WPC number
15957 of
15957 of 2021. Draws attention of the court to the final order dated 27/11/2025, whereby the said petition was disposed of with certain directions. First off, he further submits that a sum of rupees 10 lakh payable to OP number
4, 5 and 6.
4, 5 and 6, 25 at 5, 6 has already been deposited in the registry of this court
On 8th of January.
on 8/1/2026, and that he has no objection for the said amount being released in favor of the said OPs. First off, registry to process the same immediately without breaking any delay. Next one. But it is subject to condition that you will not file the appeal.
Yes, my lord, I am not.
One sentence you put it.
That was the condition, my lord.
Yes. Learned counsel appearing for the said OPs very fairly submits that his clients would receive this amount from the registry, and that they would not lay any challenge to the order in question. First off, this is appreciable. Next paragraph. Learned counsel appearing for the petitioner further submits that the amount of rupees 1 crore 25 lakh payable by his client by the direction number 2 in the order shall be remitted to the bank account of OP number
2 and 3.
No, they will have one account number, na?
No, 2 and 3 BD.
2/3 on or before 31st of this month. 31st of this month. First off, he further tells the court that in the event his client does not remit the said amount as undertaken now, his client shall not be entitled to draw any benefit under the order whereby the writ petition is disposed of.
It's a small thing.
Yes.
Minus directed in super clause number, operating clause number 3. There minus after receipt of that amount, we will release his amount 80 lakhs with interest and the rest of the amounts minus whatever minus directed. Minus this we will do minus after minus the amount is deposited by the petitioner. There are minus my amount.
We have said like that only.
Yes, minus.
This has got nothing to do with my deposit of account. You had taken the amount from him which you have kept with you.
Kindly have to paragraph.
In any case, I don't mind, my lord, my amount being utilized for any purpose.
One more thing. Learned the senior panel counsel appearing for OP numbers 2 and 3 submits that the direction number 3,
direction number
4, enshrined in the final order will be complied with after the remittance of this amount is made by the petitioner. First of all, I agree.
But and BDS would do the necessary formalities soon after receipt.
However, in the meanwhile, all paperwork shall be kept ready I'm done. Ready, I'm done. In that direction. Okay. Item number 30. Item 30. Why this IA? You don't need IA at all. We have made that order, no? An oral submission. Yeah, so please.
Item 30. My lord, item 30, my lord, I file an application for extension from time. My lord, that MSME award I have challenged in 34, my lord, and 75% award I have deposited. Later, my lord, the commercial court said that no, it will be more amount, 1 crore 20 lakhs. And I approached this Hon'Ble court, and Hon'Ble court dismissed my writ petition, saying that only extending the time to deposit the amount.
Who pays for the OPs?
Yes. Commercial court, my lord, hold that. Unless you.
Where is your application?
My application is IA, my lord, 174.
Application for extension of the period. For complying with the order.
Complying the order. To learn commercial
Let
court.
us see the order.
Commercial court, my lord, said, my lord, unless they deposit the amount, the hearing shall not be commenced. Further hearing shall not be made. Now, my lord, my submission before lordship letter submission, my lord. Now, this we have, my lord, approached file SLP, my lord, and material subsidy is there. So, my lord, may I pray that 16th of February, lordship kindly grant so that I can whether everything can be settled out there.
You have to seek orders at the hands of the apex court, not at the hands of this court. The application is filed seeking extension of the period for making the amount comprised in the order dated 5/8/2025, whereby applicants, no, you are a WP.
I am for the petition.
Applicants WPC number 9651 of 2023 has been disposed of with certain observations.
Yes.
First one. The next paragraph. Learned counsel appearing for the applicant petitioner very fairly submits that the said order is already put in challenge in SLP number.
But,
Number is
SLP number, my lord.
SLP diary number
60773 by 2025. SLP number.
SLP number.
Defect of the
SLP number
60773 by 2025.
And so first off, next paragraph. When matter is seized off at the hands of apex court, application of the kind is not entertainable. First off, accordingly, the same is rejected. How many still? 19. I think you will come off. How many are remaining now? Only 19. Left 19. Afterward. Afternoon will come.
137 only required to be accepted because you filed late.
37. The delayed submission of requisites to be accepted by the registrar. Yes.
Item 31, I is not present. Item 31.
31.
I is not present. I have filed an application for modification of the order. Your lordship's order.
Application in IA number 23434.
23434.
Of 2025, seeking modification of the order, counsel for the applicant submits, be disposed of as not fresh. First, ordered accordingly, and the application is disposed of. Yes, next. Yes, call.
Item 39. Item 39.
Item 32? 32.
May it please, Your Honor.
Yes, sir.
Against the order of revision filed by the single bench, I had filed a writ petition, but which was not maintainable and was rejected with the suggestion that review will be maintainable for that. So in course of that, Your Honor, 126 days has been delayed. I have filed a
Let us issue notice. Emergency. 33?
33 members filed the review petition with 10 days delay.
14 days delay. What is the review?
Review, my lord, your lordship said that is retired a peon manager employee, and he has given the CPF contribution, and he has given option for change of pension scheme. And at the time of disposal, my lord, the same university has granted the pension scheme, my lord, annexed 2 series, in respect of other employees. They are after their retirement. Annexed 2 series.
Issue emergent notice. Yes, item 34.
10 days.
My lord, delay is there.
Notice has to go now. Yes. Item 34.
Item 34, continuation of delayed 65 days, my lord.
What is the matter?
Matter is to sanction pension in favor of the petitioner due to acquittal from the criminal case, my lord.
Yes. What is the ground for review?
My lord, the decision may M. Paul Anthony versus Bharatu Gold Mines is favor of the petitioner, my lord.
In favor of the petitioner?
My lord.
No, question will not arise. Your dismissal was before the criminal case. Criminal case you are acquitted. Subsequently. But how that is going to help you? You were removed after holding the disciplinary inquiry. Then?
After disposal of the criminal case.
But in disciplinary inquiry, you were found guilty. Yeah. What is to do with the acquittal? What are you going to do with the acquittal?
When the Honorable Criminal Court acquitted me, additional proceedings should be dropped.
No. That is not the law.
Independent proceedings.
All independent proceedings. Not right. Review petitioner had filed WPC number 5759 of 2025. Seeking quashment of dismissal order dated 19/9/2014, contending that he has been acquitted of rape charge under section 376 of Hon'Ble IPC 1862 in GR case number 598 of 2014, disposed of on 10/2/2025 by recording the acquittal. First. Next paragraph. Learned counsel appearing for the review petitioner submits that the decision of the apex court in Captain M. Paul Anthony versus Bharat Gold Mines Limited, AR 1999 SC 1416, is in favor of his client, whereas the court, while dismissing the writ petition as a inter alia, held that it is against the interest of his client. Therefore, the order needs to be, order has an error apparent on the face of the record, warranting its recall, stroke review. Under order 40, under section 151 of CPC, read with article 226 of Constitution of India, read with order 47 rules 1 and 2 of CPC. First one. Next one. Having heard learned counsel for the review petitioner and having perused the petition papers, this court declines indulgence in the matter, in as much as admittedly he was dismissed from service after holding disciplinary inquiry, wide penalty order dated 19/9/2014, whereas the acquittal order in the criminal case was made on 10 February 2015. First one. What happens in the criminal proceeding subsequently will not cast a shadow on the order of dismissal from service. First one. In the above circumstances, review petition being devoid of merits is liable to be and accordingly rejected in limine. Registry to send a copy of this order to the OPs by speed post immediately. Next.
Item 35.
May please, your lordship, I am through BC, lordship. Here petitioner move IA for extension of time, lordship. As in late order, by passed by your lordship, 4 weeks time, given to the petitioner to ventilate her grievance before the appropriate authority. But petitioner unable to do so because of her illness, lordship. So pray for.
This court, why the order dated
Order passed 1/9/2025.
25 with the following operative portion. See, in the circumstances, what it opposes. And no person. Rest of the next one. An application is moved. Who are you?
I am the petitioner, lordship.
By the petitioner seeking extension of the period prescribed in the said order by another 4 weeks. First one. No objection. Mr. AGA, Mr. Panda, appearing for the OPs, submits that, very fairly submits that no prejudice should be done to anyone if extension is granted as sought for. First, next one. In the above circumstances, application is disposed of, granting a period of 4 more weeks, reckoned from this day. Okay.
Item 36. Item 36. Modification for us.
That modification they want. Kidney disease, column 13, to enable counsel for the applicant to come and argue. Mr. Panda, just in the meanwhile, look into whether he is suffering from kidney disease. If so, whether some lenience can be shown. In the meanwhile, Mr. Panda to confer with his clients, official clients, in regard to the player in the application. Okay.
Item 38.
One copy has not been served on us.
Copy has not been served.
That is 36.
Your copy. The Xerox and give it. Yes.
Well, in this case, kindly see page 11, madam. Your lordship directed to.
Then it come afterwards. Okay.
Eleven is the last page.
38.
38, madam.
30 is the implementation.
Yes, madam. That the order of the Honorable State Education is not complied with. For that execution case is the year 2015, madam. For that reason, lordship directed to your the case is operative page is 11. They have 2 times lost before this Honorable High Court, madam.
Hey, Mr. Panda, our officers are not doing this.
Education tribunal is not disposing of the execution application. We are given the time to filing which it is open for the petitioner to file appropriate application for taking appropriate.
Yeah, file now.
File.
Yes, this is the application.
Year number 1400 of 2026 is for that only. Ask
They have filed here. It should move before the office.
No, madam.
No, appropriate against the jurisdictional authority. We have to take action. How can that be moved before him?
No.
Kindly read
Yes,
last sentence.
approach the.
No.
So we may be given 2 weeks time then. My lord, there is some kind of confusion because the education tribunal is dealing with the
kindly read
in the above circumstances. The state the educational tribunal. OP number 4 is directed to hear and dispose of the subject execution case within an outer limit of 4 months and report compliance to the Registrar General of this court, failing which it is open to the petitioner to file appropriate application for taking appropriate action against the jurisdictional authority.
He only, authority, not somebody else. Direction is to him. You tell the who, the district judge?
No.
Huh?
You are presiding officer.
No, who is district judge? Yes. Otherwise, I'll enter a bad entry in his service record.
No, my lord, only 1 week time maybe not. I will intimate. I will.
Call on 13 person. This court wide order dated 9/9/2025 entered in applicant's WPC number 24630 of 2025 had said as entered in the above circumstances. Next paragraph. The petitioner applicant in the subject application complains that despite the positive directions, the presiding officer of the state execution tribunal,
Madam,
Education, state education tribunal.
Execution.
There's some typographical error.
Education is not disposing of the execution proceedings. First up, this is a serious matter. In view of decision of Apex Court in Rahul S. Shah, S-H-A-H, not S-A-H-A. Somebody has written S-A-H-A. Shah, S-H-A-H versus Jinendra Kumar Gandhi, 2021, 6 SCC 418. First up. The presiding officer is directed to file explanation as to why this direction has not been complied with, and compliance report has not been filed with the Registrar General as directed by this court, failing which an adverse entry may be directed to be made in his service records. First of registry to send a copy of this order to the presiding officer, Execution Tribunal.
Education Tribunal.
Education Tribunal. State Education Tribunal, Bhubaneswar. Bhubaneswar. For compliance. First one. Call on 13 by speed post. Immediately. First, call on 13/2. Okay.
If your lordship's permission, madam. If lordship's permission, madam. Also your direction and jurisdictional authority. Also
who is jurisdictional authority? You only.
No. Other 3 parties are there.
No, they are opponents.
Yes, ma'am.
Item 39. In this, I am praying for correction of the name of the petition.
Correction.
Yes, ma'am.
Correction of Bhanja Bihari Hota.
Actually, his name is Bonojo.
Vanaja. That is Vanaja. Vanaja. B. In your Orissa in northeast, ordinarily for V. B is there. Vanaja means, Vana means in Sanskrit forest. Ja means one who takes birth in the forest. Vanaja. Vanaja Bihari Hota. They have not done that. Yes, sir, Mr. Mohanty.
This is all the modification, my lord.
Modification of the order.
No, the correction of the name of.
Only the name. They sought for this modification.
Okay. It has become Bhanja. In the cost title.
Banaja Bihari.
No, but in the cost title.
Cost title it is Bhanja Bihari hota.
Bhanja Bihari hota. That should be
Banaja Bihari hota.
My lord, that Bhanja will be corrected as Banoj.
Banaja.
N-A-J.
Banaja.
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 J-A.
You want name to be Banaja.
Yes.
An application is moved seeking rectification of the name of the petitioner
In the cost title.
in the cost title of the order. In the order, because in the operative portion, in the order dated 29/10/2025, whereby the writ petition was disposed of with the following direction. In the above circumstances, also, and 2 points. Next paragraph. Learned counsel for the applicant submits that the correct name of the petitioner is Banaja, B-A-N-A-J-A, Bihari Hota, and not Bhanja Bihari Hota. Banaja, inwards, this was inward. And therefore, the same needs to be accordingly rectified. First. Learned AGA appearing for the OPs does not much oppose the same.
It's a typographical mistake of the petitioner.
Since it is only an innocuous rectification that has been sought for. First, in the above circumstances, application having been favored, the name of the petitioner should be correctly retyped as Banaja Bihari Hota, and a rectified copy of the order to be issued free of cost to the petitioner if applied for. Okay. In the cost is only when the cost is right. Other places it must be told. All. Item 40. Your petitioner.
Yes, Honorable Justice.
Yes.
The matter is a correction in matric certificate.
Correction in matric certificate.
Yes, Honorable Justice. The petitioner changed his name to Prayot Pratish Tothraj.
Prayot Pratish
Tothraj.
Tothraj.
To the Gazette notification on 3rd September 2022. Then by using the Gazette notification, he has changed the Aadhaar, PAN and driving license and some other public documents. When he approached the BSU Odisha, then BSU Odisha said that they have no provision to change in the matric certificate. So the petitioner
name to be changed.
They have corrected it and it has been gazetted.
Yes.
Basing upon that gazette, the Board of Secondary Education, they can change basing upon that gazette notification.
Only that much. Who appears for the board?
They have the panel. Normally, my lord sees that
notice is not ordered.
how is appearing.
Modification of the order.
Yes, sir. The name of the never get typed up. You want to
It is the phrase has it.
Is it a fresh matter?
No.
No. Issue urgent notice on request online case to accept notice for OP. But Mohanty appears for OP party board. Board. No, you don't appear.
They have their own panel.
This court by order dated 17/12/2025 had directed emergent notice to the board. First off, by mistake, Mr. Mohanty Learned AG was shown as representing the board.
Petitioner advocates. The expert author is not representing the petitions.
No, board. First off. Comma, when he does not have power. First, in the above circumstances, issue emergent notice to the board. First off. In addition to taking usual steps, it is open to the petitioner to serve a copy of the petition along with all the documents on the learned panel counsel appearing for the board.
Honorable Justice.
Since matter lies in a narrow compass, call on 13-2.
Honorable Justice, I have already submitted the copy to the board.
Registry to show name of to whom you have given.
Registry Advocate General. I have copy.
Which advocate?
The board office. I have submitted all the writ petition and along with also important documents to the government office.
No, not government. Board advocate is Mr. Rao.
Mr. Normally SS Rao, senior advocate there, he is entering.
You take steps now. Emergent notice.
Okay. I have also another request. The respondent number is incorrectly written in my writ petition.
Is it?
Board of secondary CON SECONDAR.
No problem. It makes no difference.
I oblige to follow.
What's your name?
Old name or new name?
Whichever.
Old is Papune Swami.
Okay.
Or new is Prayot Pratis Totraj.
Item 42 on 13 February. Item 42? Yes, sir.
41
is present, na?
But where it is disposed?
Disposed of.
Disposed in the morning at the
morning. Yes. Item 42?
My lord. That the matter is only the change of the market, fish market, to one place to another, to my place. Your lordship has ordered me to serve with a copy of the writ petition with the government advocate.
Mr. Mohanty.
Order dated 21 my lord.
Have you given representation?
I have filed the representation before the Tahsildar.
Tahsildar happens to be which OP?
My lord, OP number 3.
OP number 3.
Annexer 3 minute.
No, sorry. Annexer 3, OP number 1. OP number 3.
Tahsildar is at OP number 3 and the annexer, so far the 3 is concerned, that is also the representation. Both are 3.
Petitioner is grieving against non-consideration of his representation dated 7/10/2025, a copy whereof against at Annexer 3, wherein he has sought for shifting of the fish market to some other place in the town of Balia, on the ground that there is nuisance in the present place. First off, counsel for the petitioner submits that right to life and liberty enshrined in Article 21 of the Constitution of India, as expansively construed by the apex court from A.K. Gopalan versus State of Madras to Rajagopalan. Every citizen is entitled to live in a good weather, climate, and other environmental conditions, and therefore the fish market obviously emitting foul smell, is affecting a happy living in the area. First up, he submits that if a direction is issued for consideration of the subject representation by the jurisdictional OPs, he is likely to be satisfied. First. Next paragraph. Learned AGA Mr. Mohanty, on request accepting notice for the OPs, though initially resisted the petition, pointing out alternative remedy of nuisance suit, now fairly submits that he would instruct the jurisdictional OPs to look into the grievance of the petitioner. If all contentions are kept open and a reasonable period is prescribed. First off, with this proposal, counsel for the petitioner is also agreed. Next paragraph. In the above circumstances, petition is disposed of. Time for compliance is 3 months. Within 3 months, you have to take the decision. 3 months. First off, it is open to solicit.
Item 43.
Yeah. What the opposite part number 3 and 4.
Being a disposed of case.
The disposal.
One IA filed.
IA is for?
Lordship has a order dated 10/12/2025 disposed of the petition with a direction to the opposite party number to pursue the petition filed by the petitioner. Thereafter, they have filed the IA for a recall of that order. Copy not served on me.
Copy right now I have served.
Now, what is the ground for recall?
The matter relating to the division bench matter. This is a work apart matter. The matter relating to division bench. This Hon'Ble Court was passed this order. First portions of the order.
All matters should be before the division bench.
Division bench.
Which were the allotment, our portfolio allotment? Sitting list. Show the sitting list. What is the order we have said? Consider the representation.
Yes.
Subject representation in accordance with law.
Yes.
Yes. Okay. Having heard, application is moved seeking recall of the order dated 10/12/2025, entered in petitioner in WPC number 32092 of 2025, wherein the operative portion reads as under. Next paragraph. Learned counsel for the applicant submits that this court does not have jurisdiction over the subject matter and therefore order of the kind could not have been issued. First off, this is a bit difficult to countenance. This court being the court of residuary jurisdiction as per the allotment portfolio. First off, even otherwise, innocuous order has been made, keeping open all contentions, and therefore no prejudice is caused to the applicant, warranting recall of this order. Next part. In the above circumstances, application is rejected. Next.
No notice has been issued to me.
Solid. You consider no notice need to be issued to you. Now all contentions are kept open. Just next.
Item 44.
May I business? My lord, I am seeking for a clerical correction.
Clerical correction.
My lord. Instead of opposite victim 5.
Number 5.
Yes. Instead of opposite number 5, it
should be OP 3.
Yes.
Petitioner has moved an application seeking correction of the order dated 15/12/2025 passed in the WP. First off, counsel for the petitioner submits that the term opposite party number 3 has to substitute the expression opposite party number 5 in the relevant paragraph of the order. First off, there is force in this submission. Next paragraph. In the above circumstances, application is allowed, necessary correction to be effected, and a a free copy of the corrected order to be issued if applied for. Next.
Item 45.
There is a error, my lord. OP number 4 and 5. It has been mentioned mobile phones, but it will be Kendra. Cost title, my lord. OP number 4 and 5. Collector from district magistrate mobile phones, but it will be Kendra. Wrongly it has been mentioned.
In judgment we have wrongly printed, or in petition you have wrongly printed?
Petition. Petition only.
What was the order?
Order was to consider in the light of the order.
Representation.
Yes.
The petition was disposed of by order dated 8/12/2025 with the following direction in the above circumstances. Next paragraph. Learned counsel for the petitioner submits that the name of OP number
4 and 5.
4 and 5.
Yes, ma'am.
Although are correct,
yes,
their addresses are wrong.
Yes. District only.
To the extent that district, which district is mentioned?
Mayurbhanj has been mentioned, but it will be Mayurbhanj has been mentioned. Mayurbhanj.
District so and so is mentioned when it ought to have been Mayurbhanj. Mayurbhanj district.
But it will be Kendra.
Not Kendrapura.
Not Kendra.
No, reverse of that.
Yes.
Not done that. Okay. The prayer is innocuous. First up. And therefore merits acceptance. Next one. In the above circumstances, application is disposed of, directing, permitting the petitioner to amend the cost title of
already
the petition. You amended.
Yes, filed cost title, corrected cost title already filed.
I mean, you have to sign that after the order, not before.
Yes.
Amend the cost title. Rightly mentioning, describing Mayurbhanj district in respect of OP numbers 4 and 5 by deleting Kendrapura district.
No.
Just by deleting Kendrapura district by deleting Mayurbhanj.
Yes, exactly.
Immediately. First up. Registry to issue. First up. In terms of that, the rectification has to be done in the cost title of the order as well. First up, registry to issue. Sorry, publication. Next.
Item 46.
Item 46, Lordship, kindly see the order dated 19/12/2025. While issuing notice, the Lordship was pleased to direct to file the requisites for issuance of notice to the OP number 5 and 6. In fact, Lord, 6 is not there.
Not there.
Okay. It will be only 5.
Only 5.
Because there is no 6.
Counsel for the petitioners pressing the application supported by the affidavit.
No, I have not filed any application. So what it is?
The registry has placed this matter before the court, pointing out that there is no OP number 6 at all in the cost title, and therefore mentioning OP number 6 in the order. Interim order is any interim order
19/12
dated 19/12/2025 may not be correct. First up, there is truth in this version. First up, in the above circumstances, the order dated 19/12/2025, which mentions OP number 5 and 6, shall be construed as there being no OP6. Ordered accordingly.
The notice may be issued now because the notice could not be
issued. Issue notice to OP number
5 only.
OP number 5 only. 5 only. Okay. Item 47, you cannot tell me.
Petition matter, in this case matter, I have filed a mistake for correction of the opposite paper number 1 instead of opposite paper number 3, my lord. The petitioner representation before the opposite paper number 1, my lord.
The petition was disposed of with order dated 19/12/2025. First up, at para number 3, OP number 1 has been directed to consider the subject representation of petitioner.
The opposite paper number 3 H.
First up, counsel submits that it is OP number 3 who has to take the call on the subject representation.
Opposite paper number 1.
It is written. Oh, this is your.
My lord, I have filed a mistake.
And what is the reverse?
IA.
This for directing
the opposite one.
Directing OP number 3 to take a call on the subject representation
Instead of opposite paper number 1.
instead of
Opposite
OP number 1 who has the authority and duty to dispose it of.
Annexure 9.
The said annexure dated 28/7/25.
My lord.
28/7/2025, copy whereof will set annexure 9. First up, there is force in this submission. Next paragraph. In the above circumstances, rectification application having been favored, the final order whereby petition was disposed of needs to be rectified as the directing OP number 1 instead of OP number 3. Rectified copy to be furnished free of cost if applied. Item 48.
May I please read?
Yes.
My lord, after 5 months, and only after getting police notice by the complainant complied this order in a very peaceful manner. The first part, my claim has been allowed. Arrear has been paid. But the second part, most vital part, player was to continue in service because I was for last 7 years in that post. That has been rejected. So I am fatally aggrieved. Kindly give me liberty to challenge that order.
That's good.
Well, in all 3 matters, the order has been complied. So far the payment is concerned, that has been paid. So far the reprehension pending considered, that has been considered and ultimately rejected, that it is sought to be challenged.
But he has to challenge that. Liberty has to be reserved.
Yes.
Same order, all same party.
In 3 opposite parties are same, Milon. Because it is a college, in absence of the management committee, sub collector is in charge.
Representing for the sub collector.
48. You are saying that is complied with.
Yes, ma'am. So far as the part, my salary part is concerned, it has been paid.
But we have to give liberty to him, na?
Yes, yes.
In all these cases, complaint is as to the violation of the order.
Pardon, I have not received the order communication for other 2 cases. Only I have got in the first case content. Right now I will
give that.
Right now.
First off, learned AGA and the learned private counsel appearing for the contemners together submit that in all these cases compliance has been done, although with some delay. Do you offer apology or
yes?
They also on authorization of their clients to offer apology for broking delay in compliance. First, this court is convinced that there is a substantial compliance of the orders and therefore the contempt proceedings are liable to be dropped. First, next one, ordered accordingly, reserving liberty to the complainant to work out his remedy against rejection of part of remedy for the grievance which still remains in accordance with law. In that connection, all contentions are kept open. Yes. Okay. Wow. sentence from here. Yes. Over. This is it should be like this. So, okay, so half. Every day 1 or 2 copies you have to keep that free. So,
Happy Puja.
thank you. I wish the same to you.